Let's take a look at defamation. Defamation claims can arise anytime a person makes a statement about another person, but here the focus is on references provided by a former employer. The term reference applies here to any information that a former employer provides to a prospective new employer. The former employer need not be specifically designated by the former employee as a reference. The gist of a defamation claim is that a false statement that reflects badly on a person is communicated to others. Defamatory statements are not merely harsh or negative, they must be substantively false. As such, it benefits employers responding to requests for references to ensure that the information provided is as accurate and objective as possible. Among other things, this means basing responses to requests for information on inspection of documents rather than memory, confirming statements to known facts rather than speculation or impression. It's also helpful to have requests dealt with by designated persons who are accustomed to writing letters of reference and familiar with assessing and accessing information regarding former employees. Although truthfulness is an absolute defense to a defamation claim, employers do not want to be in the position of defending the accuracy of all of their statements. Another defense available to employers is consent. If a former employee consents to her former employer providing a reference, statements that might otherwise be defamatory will not be subject to former employer liability. It makes sense for the employer to require that any request for a reference be accompanied by a written release of information form that's signed by the former employee that grants permission to communicate information about them. This precludes off-the-cuff responses to telephone inquiries about former employees, which is also desirable from the standpoint of accuracy, but does not impose an unreasonable burden on other employers seeking references. Although requiring release forms is definitely a good idea, there's a legitimate question as to whether this constitutes informed consent on the part of former employees, because they do not know what their former employer will say. A means of gaining more fully informed consent is for employers to negotiate with employees prior to them leaving employment and to mutually agree on letters of reference. However, when the employee's departure is acrimonious, it might not be possible to agree on the contents of the letter. Some employers might also be concerned that their statements could be used against them in wrongful termination cases. A third defense against defamation claims is what the statements are made, even if otherwise defamatory were privileged. The law recognizes that communication between employers about prospective employees serves important purposes. It also recognizes that if employers have to worry about strict accuracy of everything they say about former employees, this will choke off the flow of necessary information. So, former employers providing references are shielded from defamation by claims of qualified privilege. This privilege or immunity from liability is conditional rather than absolute. In general, qualified privilege can be lost if false statements are made with malice, reckless regard for the truth. Qualified privilege shields communications only with others who have a legitimate need for that information. It's critical to have a substantive, preferably documentary, basis for references. Malicious intent is less likely to be inferred if employers refrain from drawing conclusions about whether former employees should be hired. A statement that someone should not be hired can sound, especially in court, as though a grudge is the motivating speaker.